Hello, today I'm going to be teaching you about contract law. First of all, what is a contract? A contract is a legally enforceable promise made by two or more people to perform certain actions in exchange for something of value. For example, when two people purchase plane tickets, they enter into a contract with the airline. The airline promises to take them to a certain destination in exchange for their money. There are 5 elements to a contract. The first is offer and acceptance. In a contract, an offer with all important and relevant terms must be made, and the other party must accept this offer. For example, if someone offers you a car and you accept it. Secondly, there must be consideration. After the offer is accepted, something of value is exchanged between the parties involved in the contract. This is called consideration. For example, after accepting my car offer, you receive it by paying me. The car is being exchanged for money. Next, there must be capacity. In every valid contract, both parties must have the ability or capacity to understand the terms and nature of the contract. For example, an insane person cannot possibly understand a car sale contract. There must also be consent from both parties. Each party involved in the contract must also freely consent or agree to the terms in the agreement. For example, I cannot force you to sign my contract or else it would be invalid. Lastly, there must be lawful purpose. Every contract that is negotiated in Canada must have a lawful purpose or objective. In other words, no contract can violate any law. For example, I cannot make a contract to sell a stolen car. Throughout history, contracts were written and used to sell slaves, horses, and crops. Usually, oral contracts were used. However, when an agreement was broken or did not turn out to be as expected, contracts were written in stone. For example, during the Sumerian period in 2300 BCE, there was evidence of the sale of a slave, which was written on a stone tablet to be kept in records. There are many other cases of evidence where stone tablets and scriptures were used to record transactions of items. Similar to today, historical contract law required contracts to have the element of capacity. This was known as sui juris, where animals, slaves, minor children, mental individuals, and women were not allowed to sign contracts. The Canadian Charter of Rights and Freedoms is a Bill of Rights that protects Canadians. It is the first part of the Constitution Act and was established in 1982. It guarantees many political and civil rights of people throughout the law and levels of government. Some of these sections are basic rights, criminal rights, freedom rights, and working rights. The Charter can help protect people when signing contracts. This is mainly done through the equality rights of the Charter. The Charter prohibits any discrimination towards race, religion, class, and gender. This part of the Charter protects people when entering contracts and gives them opportunities to sign contracts without any discrimination. For example, an employer cannot terminate an employee's contract because of their race or gender, or else they may face consequences in the Ontario Human Rights Tribunal.
Legislation does not apply to civil law. However, if someone commits a crime and in doing so breaks his contract, he can be prosecuted for breaking the law but can also be sued for breaking his contract.
When you sign a contract, you are legally binded to meet the contract terms and agreements. However, there are many ways you can lawfully exit a contract. First, misrepresentation. Misrepresentation is a false statement or fact that misinforms someone into entering a contract. Duress. Duress is when one party or person pressures someone into a contract through aggressiveness, blackmailing, or any other threat. Mutual agreement. If both parties mutually agree to terminate a contract, then both parties can lawfully back out of the contract. Impossibility. This means that it is possible for one party to fulfill their contract, it can be proven, and the contract is no longer valid. Breach of contract. A breach of contract occurs when a party fails to perform the obligation they owe to the other party.
A breach of contract is when an individual or party breaks the terms of their contract despite signing it. The other party or individual can take this matter into the court and receive specific solutions, such as compensation and monetary damages, which states that the party who is harmed by the breach of contract can receive compensation from the other party to the court to bring them back to where they were before the contract was breached. They can also receive something called punitive damages, which are technically used to punish the breaching party. Or they can also do injunction, which states that the court can order the breaching party to specifically stop something or face the consequences. The right side believes that there should be stricter contracts and that the government should not intervene in these disputes. The left side believes that the government should make contracts and civilians should have a say in the terms of the contract instead of private companies making them. Heller vs. Uber Technologies. In this case, the plaintiff, David Heller, initiated a $400 million class action lawsuit on behalf of all Uber drivers in Ontario. This class argued that they should be considered as Uber employees instead of independent contractors in order to gain benefits under the Employment Standards Act. The important thing to consider in this case is the company service agreement. All Uber drivers have to scroll through and read a 14-page agreement and press I agree. In this agreement, it clearly outlines Uber drivers as contractors and not employees. Therefore, these Uber drivers agree to be contractors instead of employees. Wording of a contract is very important as it dictates the actual meaning of the contract.
With the definition of a contract. So we're going to start out way at the beginning, but we're going to move pretty quick and get past that pretty quick. So the definition of a contract is a voluntary, deliberate, keyword, deliberate, and legally binding agreement between two or more competent parties. Now, normally we see it between two in the contractor world. It's either us as the contractor and whether it be the homeowner or the business owner, or maybe another contractor that would be our trade contractor underneath us. If we're selling material, then it might be us as the material or vendor supplier and the company that's receiving the material. We may have an annual contract or a one-time contract. Between two or more competent parties, contracts are usually written, but may be spoken or implied, and generally have to do with employment, sale, lease, or tenancy. Obviously, also construction and contracting, which isn't listed. Kind of ironic that the lawyers did not list. We're called contractors after all, but yet they forgot us in their legal definition. I find that ironic. So a couple reasons I point that out is a contract has to be deliberate. It has to be purposeful. So there has to be an agreement between two parties that there's going to have an exchange. And that's where the next term comes in. The next term is called consideration. And consideration is we both have to get something out of it. We both have to have value. The homeowner gets their roof repaired, their pipes fixed, a new furnace installed, new landscaping or a new kitchen countertop, whatever the case may be, we get money. Or the supplier gets money and we get parts and pieces to help us do the job. Or the subcontractor gets money and we get the benefit of their skills and labor to help us complete the job that we're working on, and we're treating them as a trade or a subcontractor. So consideration is an important term, and it means that there needs to be tit for tat. There needs to be give and take. A contract cannot be one-sided. I put in an offer. If the other party accepts the offer as is, we have both parts of a contract and it becomes a contract. And so, in fact, in Pennsylvania and in most states as well, the paperwork that we fill out as we put in an offer has been designed by the Pennsylvania Association of Realtors, PAR. So we actually fill out one side of a contract. When the receiving party gets it, which in this case would be the seller, if they say, looks good to me, sign date, contract. We have both parts. We have offer, we have acceptance. That's what makes a contract. It have to be in writing. Remember, it can be written, it can be verbal, or it can be implied. Obviously, certainly when we're providing services, we always want it to be written. It can be in the form of what I call a mini contract. Sign the bottom of my proposal and date it. It's just one page, one piece of paper that has my scope of work and my price on it. You sign and date. We have a mini contract, or it can be the 8, 9, 10-page thing that we might need for the home improvement consumer.
In conclusion, contracts are used in our daily lives for very simple tasks. However, their core function is to help businesses and individuals achieve their goals. Contract law helps businesses in two ways. First of all, it increases their revenue. Businesses can enter into contracts with various other companies under agreed terms to benefit themselves. These businesses can be contractors, developers, suppliers, transporters, etc. Contracts will allow these businesses to cut down their expenses and create long-lasting relationships which will benefit them in the future. Another way it helps businesses is by giving them opportunities. A business who finds it hard to use their own resources to transport their goods can enter into a contract with a trucking company and overcome this challenge.
Contracts also help people because people enter into contracts verbally and in writing. Job contracts lay out specific requirements and benefits that help people, giving them a long-lasting source of income. In the future, we can see more contracts being used in Canada. This is due to the fact that a newer, younger labor force will be needed to replace the older population, and they will enter into various work contracts to make money. Also, as technology increases, there will be more contracts designed by companies to use this technology. Thank you for watching this video, and I hope you have found an understanding of contracts and laws around them.